All right. Welcome to Broker Chat, Heart of Atlanta. We have a special guest today. Before I introduce our guest, for those of you that are on Broker Chat for the first time, I just want to let you know this is an event that happens twice a month. Tom Fulkerson, who is our qualified broker, we alternate Mondays from 12 to 1. This is your opportunity to ask the burning questions. Sometimes we have a subject matter we like to talk about because it's something that frequently shows up. This is also our way of complying with GREC. If we ever get a GREC call and they ask us, are we teaching you? Do we have classes? Do we discuss? We will have a recorded Zoom video showing those that have attended, those that have received the knowledge, and we also videotape these or record these and put them somewhere on Facebook or something like that. Nyala can kind of tell me where that goes. But I just wanted everyone to know this is today, we're going to have an open forum. We normally have a subject matter. And today's guest is Ned Blumenthal. Now, for those of you that may be newer in the business, you may not know who he is, but he is an attorney partner with Weissman Law. Seth Weissman is his partner. They are also the co-authors of the Red Book, 6th edition. So if you don't have that, he's going to tell you about that as well. They also teach classes, contract classes, license classes, things of that nature. If you ever decide to take one of those classes, I think they've got one of those coming up pretty soon here that I think I'm going to be attending. And then also Ned's practice, he's in the litigation department. And basically what that means is he kind of backs us, people in our industry, builders, developers, agents, brokers, when maybe you're sued or someone is filing a claim and with E&O and you have to get involved. So Ned and I have talked quite a bit this year and last year because of E&O issues. And I always enjoy when he comes on to talk to us and keep us up to date as to what's going on in the courts. And so I'm going to turn this over to Ned, but before I do that, here are the rules. Please make sure that you're muted. Type your question in chat, and then I'm going to call you when we open the floor. I'll give Ned about 10 or 15 minutes to tell us about himself, tell us what's going on in the industry, in the courtroom, and some interesting things that he's run across. And then I'm going to open the floor up for the last 45 minutes for you to ask your burning questions. So don't leave me hanging. Please have your questions ready. With that being said, Ned, thank you for being here, and I'm going to turn the mic over to you.
My pleasure. Good to see everyone, at least virtually. As Deborah said, I'm Ned Blumenthal, and I spend most of my life trying to make the world a safer place for real estate agents and brokers. And there's good news and bad news. The good news is that so far we've been relatively successful at that. The bad news is that it's incredibly busy doing that. And that there is a disclaimer I always have to address whenever I do a presentation. And there's a rumor flying around out there about me that I have to address, and it's true. I'm a recovering realtor. It's been 32 years now, and the shaking has gotten so much better than it ever used to be. Although I'll tell you, these last couple of years have caused all kinds of shaking, mostly shaking of my head, somewhere from disbelief to amusement back to just complete disbelief again. I know I'm sort of preaching to the choir here, but it's a weird world out there. And we're seeing a whole bunch of stuff, not necessarily with any real rhyme or reason to it. When I first started doing this type of work, defending brokers and agents, about 1 out of every 2 cases, somewhere 50 to 75% of the cases, all were termites. Every one was just someone didn't disclose an active termite infestation, and then it stopped. I mean, that went on for years, and then literally for the last 15 years, I didn't have a single termite case, and now they're back. I don't know what it is, but suddenly I've got like a half dozen termite cases again. Not that there's much that anybody can do about it, but just recall that, you know, there are only 2 types of property in Georgia, right? Those that have termites and those that will have termites. And just with lenders not necessarily requiring, and we call them termite letters, but they're really wood destroying organism letters, because it could be powder post beetles, it can be wood destroying mold, mildew, lots of things that can cause damage to wood. But it's one of those things where any buyer should be told, you should get a WDO report, a wood destroying organism report. And if they choose not to do so, then get them in sort of the catch-all, you must be an idiot type letter that probably doesn't read exactly that way, but functionally says, I have told you, you should do whatever it is that they're not doing here. And you have declined to get that done. And I would just constantly have it. And you can't do this for everything, but I would have it for big ticket items. Anytime your client is ignoring your good advice, and I would tell them in advance, hey, I'm going to send you an email basically that says, I told you so. And I just want you to respond back saying you got it, you acknowledge the receipt of the email. Not that I'm worried, dear client of mine, about you at all, but you're paying for the sins of those who come before you. And I just want to prove that I did warn you about this because I think it's such a big deal. And so the notion that you're not getting a home inspection done, but you're hiring you're having your uncle who once owned a house and thinks he knows something about it, come over to do the inspection. That's awesome, but that's not a substitute for a professional home inspection. So one of two things may happen. One, by you emphasizing it, they might actually do it because they realize, hey, this is a big deal. And the other is that they might turn around and develop amnesia one day after they've been in the house for a year, and suddenly the floor collapses, and then they come back and say, you never told me. And you want to be able to pull that email out and say, yes, I did, and you acknowledged it, and here it is. That can be a very effective way to shut down claims before they ever really get any traction going, because otherwise people will astonishingly develop amnesia when it serves their purpose. But the level of crazy, so we've got termites that are coming back, but the level of crazy has reached new grounds. One, and I'm going to take sort of two steps here. One is I'm seeing a lot of good seasoned agents making rookie mistakes. Really, and I think part of it's just the market that we're in and we're still in, is just, things are moving at the speed of light. And so agents that know better and should know better are just goofing up. There's just no substitute for reviewing documents, stopping, making sure that our brain catches up with our bodies in terms of actions, and that we've got everything documented, I's dotted, T's crossed, and that we aren't doing silly stuff like, when the buyer number one, when their agent sends a text that says my buyers are terminating, that we don't immediately go and accept offer number two, because one, text messages don't count under the GAR contract, and two, it doesn't matter legally what the other agent told you, it's what comes in that's signed by the parties. So while it's fine to trust and believe what the other agent's telling you, it's not done till it's done. Until you get the actual written notice that's signed by the parties, it doesn't count. So I'm seeing a lot of stuff where agents are messing that up and they're just jumping ahead. And understandably, because of this market, things are moving so fast, but it's still no substitute because frequently what happens is agent number one for buyer number one legitimately says, hey, my buyers are terminating, because that's exactly what the buyers have told them. And then the buyers go home, they have a heated discussion amongst themselves for 30 minutes, and they decide, nope, we're going to keep where we are, and we're going to stay. We're going to go forward. And meanwhile, events have spiraled out of control before they've actually pulled the trigger on anything. And we've got many multiple contract scenarios that have happened over the last 2 years, and nobody wins those things. Not even the lawyers like those. It's really somebody loses big time, and generally between the seller and the two or sometimes three buyers, they can't agree on anything except for one thing, that somehow it was the agent's fault. They all can agree on that. And then it just becomes a question of how much does it cost to chase away everyone else and just go with the one who ultimately is going to buy the property, or sometimes you chase them all away and everyone's upset with you. And I get a lot of calls regularly from folks, usually saying, "Oh, I've got one for you now." And I'm like, "Okay, what are the facts?" They tell me, and then I'm like, "Oh yeah, heard that one 3 times last week and 6 times the week before that. Bring me something fresh kind of thing. Joking with them, obviously. But I got a call a while ago from a broker who knows me and knows this story about, bring me something that's entertaining. And she said, I really got one for you. Bet you haven't heard it before. So, okay, lay it on me. Well, my agent went out to go list the property. And they met with the seller and they gave them the seller's property disclosure statement. And they said, hey, here's this disclosure statement. You need to fill this out to the best of your knowledge and belief. If you have any questions about the form, I can try to answer those for you, but I can't answer the questions that are on the form. That needs to come from you. So the seller came back and said, hey, I completed the form, but I do have a question about it. I don't know if this is something that I need to disclose. And if it is, I'm just not really sure where I should put it on the form. The listing agent said, what are we talking about here? And the seller said, well, my husband died 5 years ago. We had him cremated. Anyway, his ashes are mixed into the interior paint, which was just kind of like, what? Why? What are we, what? Just kind of macabre. And so they're like, so do we need to disclose? And my immediate reaction was, no, you don't need to disclose because you're not taking that listing. Unless they rip all the walls out and start over. Then I started thinking about it more and it was like, well, is it something that a buyer would reasonably want to know about? Yeah, probably. Is it something any buyer would ever think to ask about? No. But is it really a defect? I mean, if the paint's been up on the wall for 5 years and it's not chipping or flaking or peeling, I mean, is it really technically a defect? And I don't know whether it is or not. But then as we thought about it more, it was like, yeah, do not take the listing, or if you do, definitely disclose, because you've got a seller who has told you about this, which means they've probably told the neighbors. And so what's going to happen. As soon as the moving truck shows up, the neighbors are going to come out there with the welcome to the neighborhood gift. And it's going to be like, good luck matching that paint. And, the number of bad puns and jokes that came off of this has just been ongoing forever. My sister is a broker down in South Florida. I mentioned it to her and her response was sort of nonchalant. She's like, yeah, it's the only way she could get them to paint. And then it led to all this, is it, ash gray or bone white? And just it went on and on from there. And to my surprise, I looked up because I started playing off puns about, well, what if we covered, this is dead-based paint. Maybe we can cover it with lead-based paint and see where we go from there. And it turns out that Behr, the Home Depot brand, they do have something called dead flat white. So this craziness. But it did lead to the bigger issue that is something that I'm seeing a lot of right now, which is exactly what I was afraid those neighbors would do. They would show up and they would knock on the door and say, good luck matching the paint or what have you. And ultimately, irrespective of what it is that the buyer might do in terms of filing a claim, what they could definitely do is they could get on social media and start trashing everybody in the transaction. And that is something that we're just seeing more and more of, where people are just, their reaction, they may file suit, but then also what they're doing, even if they don't file suit, is they're just getting on social media and writing horrible reviews everywhere that they can. And those things can be darn near impossible to get rid of. Try contacting Yelp and getting them to take down, at best, they might post a response to it or something like that. But that's the type of thing that we just sort of need to be watchful for, because well, a lot of the consuming public knows that most of the time the only people that write reviews are the ones that write bad reviews, and that it's, you don't hear about the good ones. But if you get enough bad posted reviews and somebody doesn't know you, they may just flip over to somebody else. So just the type of thing to watch for, particularly when we're moving as fast as we're moving in deals, and when we have situations where we don't have the luxury of enough time necessarily to make sure everybody's feeling good about the transaction. So I'm seeing a lot of cases that are getting resolved or settled where there's no legal liability, but we're doing it just because we're trying to get rid of the stigma that maybe come from a social posting. I don't know where it's all going to lead, but it's just a fact of life that we're dealing with these days.
Let me interrupt you here real quick. I want to be able to give the audience a chance, give you a chance to get a glass of water. I want to go back to something that you said, two things, and I wrote it in the chat about we're in the technology age that we are moving fast. And I agree with everything you've said. As the managing broker in the Midtown office, Tom Fulkerson is also on this call. He's our qualifying broker. And we have some questions as well that we've run into quite a bit. I want to go back to when you talked about terminating a contract. One of the biggest questions I get from the listing agent is, can I go ahead and put the house back on the market? The seller wants to put the house back on the market. And I have to remind agents that we learned in pre-license that you technically are in kind of like a mini litigation because you're waiting for that termination to be signed and decide who gets their earnest money back. And until that's decided, you don't want to try to sell the house twice. Can you speak on that? And have you had any problems in the courts or those type of issues crossing your desk?
Sure. And this is just an area where you just sort of need to be clear in discussing it with the sellers. I mean, there's nothing that says you can't put the property back in the multiple listing services active. You can always leave it as active and you can solicit backup offers. That's never an issue. The only time where it's an issue is when you go ahead and then you're going to accept an offer. That is a problem if you don't have confirmation that the first transaction has been terminated. And sometimes you know that because the buyer, buyer number one sends you a notice of termination or sends you some other form of notice that says, and it's coming from them, not coming, or it's being forwarded to you from their agent, but it's signed by them. That indicates that they are actually terminating. Usually the TNR is what most folks use to effectuate this. And I have, and I will Deborah, forward this to you at the end of the conversation today. I came up with some language that I recommend folks use when they're in that scenario where they think they're terminated, but they're not 100% sure because they haven't gotten written confirmation back from buyer number one. And so I recommend that the seller include this in any contract that they take with another buyer. And it's basically a get out of contract free provision or nearly free. And it pretty much says that, and it says this is between the seller and buyer number two. And it says that there was a prior contract which the seller believes has been validly terminated. However, buyer number one has not yet confirmed that they acknowledge that that contract has been terminated. So in the event that buyer number one pops up out of the weeds anytime prior to closing and asserts a claim against the seller for specific performance to force them to sell the property to them, that if that happens, then the seller can give notice to buyer number two plus like $100 termination fee and just call the deal off. So it's sort of a get out of contract nearly for free provision just to avoid that scenario. The other thing they can do is just, not that any seller wants to, but they could just say, well, we're not going to enter into a new contract other than a backup until we know for sure that we've got the first deal dead. But I recognize in this market particularly, that's just probably not what the seller wants to do. They want to get it back out there and sold immediately. So I would recommend that type of language going in to the contract with number two to avoid a potential multiple live contract scenario.
Perfect. And I'll reach out to you to make sure we get that. And we'll make sure we get that out to all of you on the call. I'll probably put it in Remind under the KWMO1 mailing box, and then I'll get it to Tom as well. All right, so Yolanda looks like she's got a question. Do you want to go ahead and unmute and ask Ned your question?
Oh, Yolanda Martin, I did not mean to have my hand raised. I apologize.
Okay, all right. So I am opening the floor now. Who has a question? We know you have questions because you call us, so I know you have questions. And Tom, if you're on, if you've got something you want to jump in, please do.
Okay, will do. Thanks.
All right, don't be shy. I've got questions. If you guys don't, this is your opportunity to hear it from the grand poobah of all of our mistakes.
Deborah, you know I've always got something.
Yes, please, Jason, go right ahead.
So Ned, thank you so much for being here. We appreciate it. And Deborah, thanks for coordinating it. So hypothetical situation, we're just going to leave it like that. Is that all right, Ned?
Sure.
Okay. So seller is selling a condo while a resident of the community, the seller was on the board for the HOA. There is a pending lawsuit for against the community and the HOA, and the seller is named specifically because they were on the board.
Okay.
Does the seller need to disclose that on the CAD? If so, where? And what happens when the seller is no longer A, a member of the community, or B, a member of the HOA?
And I hate giving answers that includes it depends, but it depends. You know, if the dispute is that, you know, the lawsuit is being brought by the owner of a neighboring property claiming that the common property is somehow, there's an encroachment that's over onto their property, that something's going on with the building or with the common property, and there's now water runoff that's being directed to the neighbor's property as a result of this particular owner somehow and the association. Then that is current litigation that potentially impacts the association and potentially impacts the assessments that the purchaser might be paying. So that's something that should be disclosed. If it's in the nature of there's a fight between two board members because one of them is claiming the other one held a vote when they weren't entitled to hold a vote, or something like that, where it's personal to them, but it's not impacting the future purchaser or the property in general. It's just kind of a personal fight that has spiraled out of control. Then probably there is not any obligation to disclose that, because it's nothing that is, that's going to sort of either live on or die against the seller, but not really come back and be an issue for the buyer. So it kind of depends on the nature of what it is that's going on. And in general, the rule always is, when in doubt, disclose.
All right, great, thank you.
We're a disclosure state. Disclose, disclose, disclose. Barbara, you are up next.
Family, and I hope all is well. My question to Ned is, I do know the answer to this, Ned, but I would just like to put it out there. In our purchase and sale agreement, there is a survival of the agreement. What is there or is there not? If the seller does not execute everything that is in that purchase and sale agreement, and they go to closing and it still is not done, does the buyer have a recourse?
So the question relates to the survival language that's in the GAR contract. And so what happens if we get to closing and the seller hasn't done everything they're supposed to do?
Correct.
And so the basic rule in Georgia, if we take away the contract in general, just taking it away and if there's nothing in the contract that talks about it, the rule in Georgia is that the contract merges into the deed, is the way it's described. It basically, whatever's in the contract essentially evaporates at closing, and all that you're left with is the warranty deed. from the seller to the buyer. And so really all that exists at that point is a warranty of title. For a while, the practice, because generally folks don't want that to happen. And so they would put language in that would say that everything survives the closing. So the merger doesn't happen. And for a long time, a lot of folks got used to that. And then probably 20 something years ago, GAR, along with a bunch of other folks, did more of a modified version, which is what we have today. And so the survival language is very specific. There are only certain things that survive the closing. Any warranty of title, anything that's in the seller's property disclosure statement, representations like that will survive the closing. The party's obligation to pay a commission survives the closing, plus anything between buyer and seller that they have agreed can or will be done after closing. So if there is nothing that says, and I see this a lot where, and this is one of these ones where for some reason, a lot of folks have these like really expensive, they're crazy expensive, six-figure doll houses. They call them doll houses, but they've got real running water. They're on foundations. They're huge. You got to put them on a flatbed. I've had several cases where this has happened, where there's this doll house that the seller was intending to take with them, but they didn't specify in the contract that they could come pick it up after closing. And so the buyer went in, they closed, and then the seller came out the day after and started to like jackhammer this thing up off of the foundation. And there's some technical language in the law when you go on property that you don't own or don't own any longer, and you remove stuff that's not yours. And they called the cops and had these folks arrested for trespass and attempted theft of property. So it cuts both ways. If the seller's supposed to have repairs done, they're supposed to make repairs, they're supposed to do whatever it is they're supposed to do. If they haven't done it prior to closing, and there's no language anywhere that says that it can be done after closing, and the buyer goes ahead and closes, then that obligation goes poof. That's another legal term, poof. It just goes away. So if what the buyer would do and should do in that scenario is they should do a quick amendment to the contract that says, we agree that the seller will do whatever it is they're supposed to do within 7 days after the closing date, assuming that the parties don't just want to hold off and postpone the closing while the seller goes and does whatever it is they're supposed to do. But it can work in the same way in reverse, that if the seller wants to take something from the property, they need to make sure that they have put language in that allows them to do that after the closing, because otherwise they're going into property they no longer own and removing stuff that's no longer theirs.
And Ned, one more thing, that would also apply to rose bushes as well. Am I correct?
I'm sorry, to apply to what?
Rose bushes.
Right, yeah, anything. A rose bush, whether it's a dollhouse or a rose bush or pretty much anything. Once it's sold, it's sold. And if the seller has not put in the contract that they can come in and remove the rose bush or the dollhouse or whatever, then they can't once it's closed.
Thank you, Ned.
Sure.
Thank you, Althea. I'm sorry, Barbara. Althea, you are up next. You still there?
Sorry about that. That was an accident. I was trying to get into the chat.
Oh, okay. All right. So are there any other questions?
Yes, I have a question, Yolanda Martin.
Go right ahead, Yolanda.
Thank you. Sir, so assuming all of that happened that you were just explaining, a property closed, it survived closing without the agreed upon repair. Somehow it closed. And now the attorney informed that particular buyer that they can go and find another property that the seller owns and place a lien on it to get that repair satisfied. Can that happen?
Anybody, look out the window and pick a car, any car. We can sue the owner tomorrow for the accident you never had 2 years ago. So anything can happen. It doesn't mean you're going to win. And no, if you have, you can't just go place a lien on someone's property someone's other property because they failed to do complete repairs on your property. If that buyer sues the seller and somehow wins that suit and gets a money judgment against them, then that judgment can be filed in any county in Georgia and it will act as a lien on the real estate. But they got to go through that whole process first of getting a judgment and then filing it in whatever county the seller owns real estate in, and then it'll act as a lien. But they can't just go out and just sort of randomly find some other property that the seller owns and say, I'm going to file a lien against it. They get themselves sued for slander of title.
Oh, thank you so much for that, because that came from an attorney that told them to do that. So I appreciate that. Thank you.
Sure.
Can I piggyback on that question real quick?
Sounds like Barbara, go ahead.
Okay, this is Chris.
Okay, sorry.
So with that question, what about the vendor? The vendor is wanting to put a lien on the property, not the buyer.
So we've got a scenario where the seller has had some repairs done to the property. They didn't pay the mechanic or material man.
Right.
They didn't pay them, and then they're coming out and they're leaning the property.
Another property.
Yeah, they're not going to be able to lien another property. Mechanics and
Oh.
material man's liens are specific to the property where they have provided work or material.
Okay, thank you.
So-
I just wanted
so-
clarity.
Yeah, it'd be the same thing. If they get to the point where they get a judgment against the seller, then they can file that judgment and it'll act as a lien on their real estate wherever it is in the state. But in general, a mechanic or material man can only file a lien on the property where they've actually supplied the work of the material.
All right, Sharon Anderson, you're up next.
Good afternoon. Ned, I have a client that was scheduled to close with your law firm on the 4th of May.
Mhm.
However, when we went out to do the walkthrough on the 3rd, we discovered that someone had moved into the property. A colleague of mine who does property management told me that there is what's called a squatter's law, which says that if you discover within 24 hours that someone has moved into your listing or property, that the police can just ask them to leave if it's within that 24-hour period. However, if it's longer than that, there's nothing you can do except take it to court. You can't turn off any utilities. You can't do anything. So I'm trying to educate myself on this squatters thing because I was just blown away when I discovered someone had moved into the property.
Yeah, there's a lot of crazy out there. There isn't a squatter's law per se. There's more of a practical issue. If you go out and you discover that somebody's in the house and they're not supposed to be there, definitely call the police. Whether you can convince the police that they need to escort these folks out, or whether the police are going to look at you and say, well, it looks like a civil matter, you need to go file a dispossessory warrant, is the issue. And it's really just a matter of being able to convince the police that, hey, no, this is criminal and these people need to be, hauled out of here. If somebody's just in the house is vacant and there's, a bedroll or a sleeping bag or something down on the floor and, box of old Chinese food sitting on the counter kind of thing, you might get the police to believe you that, hey, this is a squatter and, here's the rock that they threw through the broken window to get into the property. But if you go out there and you call the police and you say, hey, these folks broke in and they moved an entire house full of furniture in, and it's all furnished and it's all their stuff, and they've clearly been here for a while, then the police are much more likely to say, yeah, this doesn't look like a typical break-in. This looks like somebody's been here for a while and we're not sure whether to believe you or whether to believe them when they say, oh no, they rented the place. And so they're much more likely in that case to say, why don't you go file a dispossessory action in magistrate court and let the judge sort it out. So it's not so much that there's a squatter's loss as it is that it's just a matter of, trying to convince the police that, no, this really is a criminal breaking and enter issue and not some sort of a tenant dispute.
So there is no recourse in terms of being able to do something to make them uncomfortable to try and force them out, like cutting off utilities?
Generally, no. You sort of run the risk. I typically say, my typical advice would be just go with the process of filing a dispossessory warrant. You can file, the process will take a while just because the nature of it, it can take a couple of weeks. And then you got to be very active these days. Once you get a warrant allowing you to set out, you got to have to be very active with the sheriff's office, telling them, hey, look, this is not a typical dispossessory action. This was a squatter, and bump us to the top of the list, please, to try to get rid of them. There's just been too many instances where somebody's in the property, whether they were there legitimately or not. Someone comes in and they kick them out without going through and getting a dispossessory warrant, and suddenly the claims start coming in of, you locked me out without my knowledge or any kind of court order. You don't have the right to do that. And where's the gold? Where's the diamonds? Where's the flag that was on great granddaddy's coffin when he came back from the big war? I mean, it's that kind of stuff. So as much of a pain as it is, if you can't get the cops to set them out, file for a distress warrant, a dispossessory warrant. It's the safest way to go.
Okay, well, that's good to know if I'm on the listing side. I'm the selling agent on this transaction, and the squatters produced a bogus lease to say that they had been scammed. And so the police did advise the listing agent and the owner to proceed with court action. But thank you for that information.
Sure, and we see that a lot with, you see the Craigslist scams, where sometimes they're not squatters themselves. They've legitimately been scammed. Somebody hijacked the listing, stuck it on Craigslist, got into the house somehow, picked the lock or whatever. And, we've had a lot of folks that have gotten calls from these people who show up at the house and they're there trying to get in. And they're like, we paid our first and last month's rent plus our security deposit plus, and we're here. The key that we were sent doesn't work. And we see you've got a sign in the yard. How do we get in? And you're kind of like, who are you and what are you talking about? Someone's just ripped them off a bunch of money.
Yeah, we've had lots of news stories on that. And you're exactly right. It comes from Craigslist or some of the other platforms that they're advertising your listing and then, scam that potential tenant out of money. So good question, Sharon. Thank you for that. Ted, Ned, I want to ask you, I don't know what's wrong with me with names today. I want to ask you, what kind of issues have you had with, if any, with appraisal gaps? We're in this aggressive market of using different tactics like option money, appraisal gaps, things of that nature to win the deal. What are you running into? We just had our May 1st updates to our contracts, and we noticed a couple of items that I really like that have been added to the contract, and then some that I don't know if it really even makes sense, but it's there for a reason. And I usually tell agents is because we've had some kind of litigation about it. So now we're updating our contracts. What do you say about that?
All right, so several things. First, I want to address the bigger issue, and that's the pick me issue. All right, what this is all about is it's pick me, pick my offer over every other offer. That's really what's fueling this. And I very strongly recommend that buyers be told, hey, look, if you want the best chance of getting this, you're going to have to make a really stupid offer. And there is a GAR form that we put together that is basically you're going to be making a stupid offer form that says things like, if you buy a property and you are offering more than the asking price, you might be paying too much for the property. If you're buying a property and you're not having it inspected, guess what? There might be things there that you wouldn't like and won't like, that you would have discovered had you had an inspection done. If you're buying the property and you never stepped foot on the property, you may not be happy with the property once you do step foot on the property. So at a minimum, use that form. But what I'm telling folks, and this your mileage will vary undoubtedly, but to me, if I'm a seller, the pick me moment is, hey, I've got some buyer who sent me an offer. It has reasonable terms and conditions. It's got a 3-day or a 5-day due diligence period in it. But instead of just in the way the form is written, it's got sort of, for the due diligence period, there's this nominal $10 consideration that's just recited in the form. But on page 1, there's a place where you can put down real money for option money, and it goes directly to the seller. It doesn't go to the brokerage. It comes directly to the seller. And so if I've got an offer and one's pie in the sky high, and I don't know whether these buyers are good for it or not, they're just trying to lock it up. But I've got another offer. I've got another offer from somebody who says that here's $10,000 for option money, and basically it's yours, seller. Even if you terminate, even if I, as the buyer, terminate during the due diligence period, that money is gone. As a seller, I may pick them because they seem invested in this. They seem to be more serious to me. Now, the downside, if you're that buyer, is that if you decide you don't want the property, your money is gone. So you got to, choose wisely on what to do with it. So that's sort of the broader question on the pick me thing. If we are going to start playing with appraisal contingencies, and this is another form I will forward to you. I put together, and Seth put one together as well. Mine's a little bit different, but they both do the same thing. Mine's a little bit more of a formula. But the idea is that you really need, both parties really need a floor and a ceiling on the purchase price. The buyers get it that, hey, I don't want to pay more than the purchase price. So they'll say things like, buyer agrees to pay, in the event the property appraises for less than the purchase price, buyer agrees to pay appraised value plus 10,000, not to exceed the purchase price. Problems with that language, several problems. One, the buyer agrees to pay does not say, and the seller agrees to accept. So I don't even know if we have, it's maybe implied in there, but it's not specifically stated. And I don't know whether that overrides any appraisal contingency that's contained in a financing contingency. In other words, does it mean and the financing contingent, any appraisal contingency in the financing exhibit no longer exists? Or does it mean, for example, right now, without messing with anything, if the appraisal comes in low and we have a financing contingency on a conventional deal, then there's that time period where the parties can, the buyer can ask the seller to reduce the price, and the parties go back and forth and they either agree or they don't agree. One reading of language that says that if the appraisal comes in low, that the buyer agrees to pay appraised value plus 10,000. One reading of that is that, and that's the purchase price, period. But a second reading is that the buyer can't ask for the price to be reduced all the way down to the appraised value. Instead, they have to ask for the price to be reduced to the appraised value plus 10,000. And that the appraisal contingency in the financing exhibit is otherwise still active, which means they gotta comply with all the time periods in there. And if they don't comply with all the time periods, they may be waiving the appraisal contingency. So a lot of issues. One is you need to specifically state whether, if we're doing this in a special stip, we got to specifically state whether this special stip overrides the appraisal contingency in a financing exhibit. Two, we got to state that this is whatever it is that we're using to set the price, sets the price, not just buyer agrees to pay, but that this will be the price. And then the third is we need to have something that says, and if the price ends up being lower than X, then the seller can terminate, because that's where we see a lot of this stuff come in. Everybody assumes, oh, well, we're putting 600,000 on the property. If it comes in a few thousand low, that's okay. The seller will pay the difference. The buyer will pay the difference to get it up to the 600,000. But in comes the appraisal at 525. And the buyer's like, woohoo, I get it for 535, appraised value plus 10. And the seller's like, whoa, wait a second. I never agreed to that, except they really did, because their contract says the property price will be the appraised value plus 10,000. And, we've seen a lot of those. So I'll forward you, Seth has some language out there. I'll forward you mine. And either is fine. They both accomplish the same thing. It's just a question of conceptually what resonates with everyone. Mine basically sort of sets there are two, there's like an X and a Y, where X is the amount of the appraisal, and Y is the floor price. And you basically is like a comparison. You take the purchase price, you compare it to the appraised value, and then you add X to it. And then you see it's not going to be more than the purchase price. Instead, it's going to be the appraised value plus this X, whatever that turns out to be, unless it's lower than Y. If it's lower than Y, then the purchase price is Y. So we got a floor and a ceiling, and it specifically overrides any appraisal contingency that is anywhere else in the contract. One issue that has been an ongoing issue that is addressed in the updated forms deals with what if we've got FHA or VA? And that has been an issue where there is no clear answer to it, although now there is. So, with FHA and VA, you have the amendatory clause that says, in effect, that if the property doesn't appraise for the purchase price, then the buyer has the option of walking, period, and they get all their money back, no questions asked. Just they get to walk and get all their money back. And the question is, well, what happens if you put a special stipulation in that messes with the appraisal and does one of these, we're changing the price? Well, FHA and VA and the amendatory clause is regulatory. It's part of, you can't get an FHA VA loan without the amendatory clause, but there's nothing in there that is statutory. It's not like the contract is invalid or there's no, parties can't contract to do that. So it created this issue of, well, what trumps in that instance? Which one is it, the amendatory clause, or is it the special stip that everybody came up with? And ultimately, the Forms Committee's solution, which is now baked into the contract, is that the amendatory clause wins. So efforts to try to negotiate around the amendatory clause are not effective, according to the new contract set that's out there. And the reasoning behind it really is, I think, very sound. Let's say we don't have that language and we leave it up in the air. We've got an FHA or a VA loan, and we got special stipulation that says that effectively the buyer is going to pay the full contract price no matter what it appraises for. As a matter of Georgia law, it's probably enforceable, except it's impossible for the buyer to get an FHA or VA loan because you no longer have an amendatory clause. So we're contracting to do something that is legally impossible to do, which we want to avoid. So I think the ultimate answer, and the answer that the Forms Committee came up with, is the amendatory clause prevails. So basically, don't go messing with, don't expect any efforts to mess with the appraisal contingency to hold up in an FHA or VA transaction, because the contract says that the amendatory clause is going to override all of that.
Yeah, I think for everyone to understand, the amendatory, that was always the case. But now that it's in writing, because Ned, that's a question that always comes to me. Well, can we write something? I said, you could write all the things you want, but it's really tough to override guidelines of VA and FHA. So yeah, that's just something that I've always known. Yeah. So I'm glad they did write that in. Mm-hmm.
Yeah, it becomes impossible to perform because they just, no matter what the parties say, the lender won't lend. They can't lend unless you've got the amendatory clause. And so if we're removing it, then we're making it impossible for the buyer to perform.
All right. A question from Joel. Hey, Joel.
Hello. Question is, what is your suggestion when it comes to talking to sellers and them having cameras in the house?
So the rule in general is that in Georgia, it is permissible for a seller to have a camera in their house and to have a camera on the what they call the approach to the house, basically the exterior of the house and any walkways, driveways, whatever, the curtilage leading up to the house. That is legal for them to have. My recommendation generally, just to avoid any kind of claims or issues, is that if the camera is visible, if there's something where you just can't help but notice it, then fine. But if the cameras are there and they are on and they're otherwise not visible, then I would leave a card or leave something or put it in private remarks or something that just says video surveillance in use, purely for the purpose of avoiding any possible claim that may come up. A couple of issues with that is that you can't use the camera anywhere there is a reasonable expectation of privacy in the house, even though it's the seller's own house. That means no bathrooms, no cameras in the bathroom, period. Some people have suggested that maybe the bedroom should be off limits, but personally, I think it's, unless you've got guests staying over or something like that. If it's just, we're talking about basically just buyers, potential buyers coming through, bathrooms, should not be any camera recording equipment in there. And actually what I'm seeing and what I'm hearing about a lot of times these days is that buyers are actually expecting and hoping that there's cameras in use in the property, and they're arranging code where they go in, they see a house, they really like it, and they expect and hope they're being recorded, and they'll stage this conversation amongst themselves where they'll go off into the kitchen somewhere and they'll be like, oh, this house would be great, if they would come, but it's almost as good as that last house that we saw. That one was really the best. But I tell you what, if these folks would come 10,000 off of their price, this one would win. And they're just making it up and staging it, hoping that the seller sees that, so that the seller's like, now I got them, and now it's more like the seller's got the buyer exactly where the buyer wants them. So there's all kinds of stuff with that. But my recommendation, just erring on the side of caution, is that if it's not obvious that there's recording in use, go ahead and let prospective buyers know it, either by sticking a card somewhere at the entrance to the home, or by putting it in the remarks in multiple listing service, just so we don't end up with some sort of crazy claim coming in.
Thank you.
Ned, I have a question about notification. It's another thing that seems to pop up where when an agent calls with a broker issue, and I will ask the question, we all know that if we're wiring funds these days, but sometimes a buyer will write a check, maybe it bounces, we're supposed to send a written notification. But the contract reads that everything needs to be written and notified. So if someone is breaching the contract, we should use that notice form to say, as of today, you've breached that contract. What kind of comment do you have about that? Because I think that's another area where we're moving too fast and not doing that. And then as the brokerage, we don't have proof. Everybody wants to send me their, laundry list of text and emails. I'm not going to read that. I want to know that you sent a notification indicating that that person breached.
Yeah, I mean, certainly, the notice can be on any, there's no one way that the notice has to be sent, but the GR notice form is the best way to do it, just because it is, just right on its face, it's notification. It says so. It says this is to notify you. So there's no dispute over that. Sending texts is not a valid form of notice ever, even though people are doing it left and right. And there's nothing wrong in the abstract with sending somebody a text, as long as you then follow up with an approved form of notice by sending them an email typically. So make sure that we've got that done. And just more broadly, this falls into the category of deferring notices. As realtors, we are hardwired to be in the good news business. Whereas with me now, with the lawyer hat on, we're often wired to be in the bad news business. So it's a little unnatural for agents to sort of embrace the bad news business, but nothing ever good comes from deferring or delaying giving bad news. there have been a number of claims where folks have gotten sued over that, where they have, I'll give you this is the most extreme example that I've personally dealt with, but it's at least illustrative of some other issues that happen, where somebody went out, this was a few years back, we're not in the current market that we're in, we were much more in a buyer's market. And this guy came along and he put an offer on a very expensive home. It was a builder custom home. And he was putting down $100,000 earnest money. And based upon the strength of that, the builder agreed to go ahead and install a wrought iron fence around the entire perimeter of the property, because he knew that this was a serious buyer who put down $100,000 earnest money. Well, the earnest money check bounced, and the buyer's agent went back to the buyer and said, we got a problem here. The check bounced. And he said, I'll take care of it. That's my crazy uncle. He's in charge of all the money for the family. He's pissed at me because I didn't call him last week and it was his birthday, and this is his way of getting back at me. Don't worry about it. I'll take care of it. And the agent said, well, I think I need to notify the seller. And the buyer like blew up at the agent and was like, don't you dare. You're going to cost me this deal. You're going to cost me this house. I will sue you. I will not stop until you are in bankruptcy, and just really did a head job on this lady and intimidated her to the point where she didn't say anything for a month. And then only finally at the end, she went to go see her broker, who said, we need to notify everybody immediately. And the buyer, he just evaporated. He was just, who knows what he was, but he wasn't real. And he just disappeared off of the grid and off the face of the earth, never to be heard from again. And meanwhile, the seller came back and was like, well, buyer's vanished, but I'm owed the earnest money. Please pay it to me. And the broker had to say, yeah, we never collected the earnest money. And the seller was like, what do you mean? You were supposed to notify me if you didn't get the funds or if they bounced. No one ever told me. And in the meantime, because as far as I know, you were holding $100,000, I put this wrought iron fence around the house. That cost me 75 grand and my cost to do. And they came after the broker and the agent for the 75 grand. That between the agent coming out of pocket, the broker coming out of pocket, and their insurance company paying some combination of them own a very expensive chunk of wrought iron because they ended up paying for it. Don't delay giving bad news when it comes, specifically when it comes to issues of earnest money. Got to notify everybody right away.
Did I hear you say, Ned, that email was okay to use as a form of notification?
As long as the notification, so if it's, yeah, yes, but if it's, if as long as it's an acceptable form of notice under the contract. So if the agents have put their email address, then sending notice to them through there is going to be notice to their clients. But if it's notice coming from the broker, so if it's a holder issue, if it's an earnest money holding issue, then the broker is sending that notice, then that's fine. Where it's not okay is if the buyer is saying, hey, we're going to terminate. And so the buyer's agent just sends an email to the listing agent that says, my buyers are terminated. That is not notice because it is not signed by the buyer. So if it's notice, it's supposed to come from one of the parties. It needs to be signed by one of the parties. So a buyer could send their agent an email that says, we are hereby giving notice that we are terminating the agreement. Please forward this to the seller. And if the buyer's agent forwards that email to the seller's agent, then that's going to be notice, because you have something signed, digitally signed by the seller going across. But to avoid that fight, just get them to sign a termination notice and then forward that by email.
So much. Well, guys, this has been fantastic. I hope you enjoyed it. I always like bringing in the people that kind of dictate our contracts and create the books for us to follow. Sometimes it's better to hear it from them than from us, because we are telling you that. So now we've got someone repeating what we've been telling you. So thank you so much, Ned. I'm going to give you like a couple of seconds here to kind of give us an idea of how people can get the Red Book if they so choose to do that, and then we'll sign off.
Sure. So the Red Book, we started as a project years and years ago, where it's designed to be sort of like a handbook for agents out in the field to take, and there's like hundreds of special stipulations, and it sort of explains basically how the GAR contract works and your obligations under BRETA. And it's really designed, and it's updated every roughly 5 years by largely questions that we get, scenarios we see. Anytime something new comes up, it works its way inevitably into the Red Book. There are two ways to get a copy of it: a hard copy, a physical copy. You can go to our firm, to Weissman.law, www.weissman.law, and there's a link you can click on to order it. But it's now a 2-volume set, so it's suitable for holding 2 doors open at the same time instead of just one. So a lot of folks are getting the digital version, which you can go to Amazon or to Barnes & Noble or anywhere where ebooks are sold, and you can get it in a digital form, which is what I suggest, because it's searchable that way. So if you're used to doing something, looking at books digitally, I would certainly recommend that, just because it's a lot easier to scroll through it and find what you're looking for.
All right. I'm putting that in the chat for those of you that want to go to either Weissman Law to get the hard copy, or you can go to Barnes & Noble. I have both. The 2-volume is large enough to use as a doorstop, because I've gotten every copy since they started doing this, and it's very valuable as a go-to book to look at different special steps that are not even included in our special steps index. So it's very helpful. Ned, thank you again for doing this. We hope to bring you back again. Hope everyone enjoyed this, and look forward to Broker Chat in June. Thank you, guys. Have a great day. Go sell some real estate. Happy birthday, Barbara. Thank you, Ned.
My pleasure. Be safe out there.
Thank you for the birthday greetings, guys. I appreciate that. And one more question. Will we be able to get those handouts that Mr. Ned said he's gonna send?
Yes, when he sends them to me, I'll make sure Nyala and Tom get those, and then that way it can make it out to the other market centers. And for Midtown, I will make sure that our productivity coach in our office, we send those out to you guys as well.
Okay, thank you all. Have a great day and a wonderful week.
Thank you. You guys have a great day. Bye-bye.
Thank you.
Okay.